Hello, and welcome once again to Lehto's Law. I'm Steve Lehto, attorney at law in the state of Michigan. I've been practicing law for 25 years in the fields of consumer protection and lemon law. I often write about the stuff at places like roadandtrack.com, and I've written a few books along the way. Today I'm going to talk about why you cannot return a stripped VW TDI as part of that big buyback program for Volkswagen. So sorry, you cannot return a stripped VW TDI. I'm sure you know that Volkswagen got caught up in a controversy with their diesel engines a while back, the TDI controversy, where they had these cars that somehow beat the emissions tests in a way that nobody understood until they figured out, hey, wait, they're just cheating. These things don't burn cleaner. They're just cheating. They had a cheat device built into them, and I'm not a computer guy, so I don't exactly know how it worked other than to say they got caught red-handed. And so as part of the litigation that ensued, VW has agreed, as part of a class action settlement, to pay about $15 billion to buy back almost 500,000 cars in the U.S. And that's if everyone takes them up on it. There's a few different components to the story, but what we're talking about today is the buybacks. In other words, you have a VW TDI, it cheated, it got caught. Volkswagen's now going to buy it back from you and pay you some money. Now, I've done a previous podcast on this topic, and I said that I advise you to take that buyback offer. I believe if you want to, you can opt out of the class action and file your own lawsuit and see if you can do better. No guarantee you will. You could do worse. So I said, hey, you should probably do this because someone else has done the work for you. And so the buyback process has begun, and people around the country are checking in. They're getting their vehicles bought back. They go to the dealership, drop their car off, get some money, and they walk away. Well, there's a big story that broke a couple days ago on the news. In fact, our buddies over at Jalopnik did a big story on it, where a guy who was a little disgruntled, shall we say, had a Volkswagen TDI, and he stripped it. And he removed the hood, the doors, a whole bunch of other stuff. But the car still drove under its own power. And he said, I'm going to return this thing, and they've got to give me my money back because it does move under its own power. And he said that he was basing it on language directly from the settlement document. And so if you want to, you can double check my math on this. But on the internet, you can find this lengthy document. It's hundreds of pages if you read all of the attachments and so on. But it's the partial stipulated order for permanent injunction and monetary judgment. Okay? And it's a court order. And it's online. It's a PDF. You can read it yourself. And the guy who was in the Jalopnik story said he was going to do this because according to the settlement agreement that he saw, and he's right, it does say this, he said, it says a vehicle must be operable in one place, and it defines operable on page 10, subpart II, I kid you not. Operable means that the vehicle so described can be driven under its own 2.0 liter TDI engine power. A vehicle is not operable if it has been branded, assembled, dismantled, flood, junk, rebuilt, reconstructed, or salvaged, blah, 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 blah. So the guy says, right there it says, an operable vehicle is one that is self-powered. Therefore, if I simply turn in a vehicle that is self-powered, they got to give me my money back. And so he told this to the people at Jalopnik, and a bunch of people ran the story. A lot of people repeated the story also. I've been having people fire me questions. In fact, a gentleman sent me an email last night and said, Steve, what do you think about this? Which is why I'm here right now talking to you. This is an unusual podcast in case you're curious, because today is December 21st, and this podcast is going up December 21st. I rarely shoot podcasts on such short notice because I'm always scared of screwing up the editing process. So this will be online in about an hour and a half. But this, like I said, is the result of an email I got last night that said, Steve, you should do something on this, and I've now gotten several others. So I thought to myself, when I first saw the article on Jalopnik, I thought, that can't be right. The guy can't possibly be right, and he's not, it turns out. But again, this is what happens when people go and they read legal documents without ever bothering to ask an attorney or somebody who knows what they're talking about to read it with them and say, does this say what I think it says? Because, like I said, there's 158 pages, just the one document I'm looking at here. And yes, on one page, you can find a thing that says an operable vehicle is a vehicle that can be driven under its own engine power. Okay, so you say, what? That sounds reasonable, that's operable. And so they say all you got to do is return an operable vehicle. It's not what they say, though. Okay, that's just defining operable vehicle. They define all kinds of things in this section. Elsewhere in the document, as you might imagine, is language that suggests what you have to do. And when a court interprets a settlement agreement or a contract or even a statute or a law, they tend to look at the whole thing, the global perspective, and they ask themselves, what were we trying to accomplish, or what were they trying to accomplish with this document? So if someone were to go to court and argue and say, hey, I believe I've got the right to return an operable vehicle after I've stripped all these things off of it, and this document says I can do that, the judge is going to say, okay, fine, let's look at the document. But you don't look at just the document in that single definition. You look at the whole document. What does the whole document say? And elsewhere, I found Exhibit 1, which is the settlement benefits to class members. And this primary 158-page document does say throughout it, see Exhibit 1, see Exhibit 2, as elsewhere defined in Exhibit 3, that kind of thing. And Exhibit 1 defines exactly what you get in exchange for your car. And it says base values for eligible vehicles on page 4, and this is paragraph 11. It says the base value for each eligible vehicle is, where available, the clean trade value of the vehicle based on the NADA vehicle identification code for each eligible vehicle, blah, 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 blah. But the key here is it says that they're specifically defining the value of your car based on the NADA, which of course is an acronym, the National Automobile Dealers Association, I believe. I could be wrong, but that's close. And clean trade value is a term of art. Clean trade is capitalized here. Clean trade, capital C, capital T. Clean trade value of the NADA Blue Book value for your car. And if you're curious, you can go to NADA's website and see what clean trade value means. And clean trade value means, quote, a vehicle with no mechanical defects and passes all necessary inspections with ease. Okay? So if you remove the hood, the doors, the bumpers, the hubcaps, whatever you've removed from your car, it would not pass a necessary inspection with ease. So it's not clean anymore. It also says with all equipment in complete working order. Again, your vehicle missing equipment no longer has all its equipment in complete working order. And finally, it says, a clean vehicle will need minimal reconditioning to be made ready for resale. So if you've stripped the vehicle, it is no longer needing just minimal reconditioning to be made ready for resale. So if you read this entire document, like I said, if you want to, you can. If you've got nothing better to do for the rest of the weekend, knock yourself out. It's 158 pages for the judgment, 8 pages for Exhibit 1. Other exhibits are longer. But keeping in mind that the judge who's going to be asked to interpret this and be asked, can people strip these vehicles and turn them in? He's going to say, well, let's take a look at all the different things in this document. And if you take the aerial view, step way back and look at what this entire document's trying to do. What the document's trying to do is it basically says, look, there's a bunch of people here with defective vehicles, but the defects are the cause of this other party. This other party has agreed to buy all these vehicles back. And so, money's going to go this way, cars are going to go that way. If you're listening to the podcast and you can't see, I just pointed in diametrically opposed directions with my fingers. And it does say elsewhere in this document that Volkswagen can, if they're capable of doing so, make the vehicles they bought back comport with the EPA standards on emissions. And if they can do that, they can then resell the vehicles. So it doesn't make sense that this document would allow people with defective vehicles to strip them of everything that's got nothing to do with the emissions and give them back to Volkswagen. Because if Volkswagen wants to take a vehicle and put it back in the market, they can't do that by simply addressing the emissions. Now they've got to go find a hood, doors, seats, and whatever else has been removed from the vehicle. So it doesn't make any sense. So just taking the global perspective of the document, I believe a court would simply say, obviously, we intended you to return the vehicles intact, okay? And you can read into it by, like I said, finding the clean trade value is defined elsewhere, and that's built into this agreement. But it also makes sense if you look at how the Lemon Law works. And I back at the very beginning of this, I actually said I was shocked that Volkswagen had agreed to buy all these cars back because it's very similar to a Lemon Law remedy, and that's the most extreme Lemon Law remedy. Because quite often, if you have a defective car, a manufacturer will say, instead of buying it back from you, we'll just give you some money. Just live with this. Just take this money and be happy, And so to actually do the full buyback, that's like the Grand Slam home run in the World Series. That's the biggie, okay? That's the most you're ever entitled to. And so for them to come around and say, we're going to do that for 500,000 vehicles, I thought it was mathematically impossible. I didn't know there was enough money on earth to do that. But apparently, Volkswagen had about $15 billion laying around, nothing better to do. And they said, oh, we'll throw this money at the problem. So they did it. But when you get a vehicle bought back under the lemon law, and I've had to explain this to clients now for 25 years, every so often a client will call me up and say, Steve, I understand that you got General Motors, Ford, Chrysler, whoever, to buy back my vehicle from me, and I'm going to get all my money back. Can I now take a can of spray paint and spray paint all over the side? You know, Chevy sucks, Ford sucks, Chrysler sucks. And I go, no. They go, why not? And I say, since I'm the adult in this conversation, number one, the agreement says you've got to return the vehicle in good condition, and the only thing that can be wrong with it, other than the problem for which it's being bought back, is reasonable wear and tear. Okay? So in other words, if your car's got a bad transmission, you can turn it in with a bad transmission, obviously. But it can have wear and tear, but it can't have a broken windshield, dents in the body, and so on. And people say, why not? And I say, because they're going to take this vehicle, wash it, wax it, and sell it. And people, well, what? They're going to sell a lemon? And I say, yeah. In fact, there's nothing wrong with that because most states don't require them to even bother disclosing, but most of the big three, as far as I know, do. But along with that, they're going to recondition the car. They're going to fix what's wrong with it. But they have to somehow be able to recoup their money here. If they couldn't recoup their money, they'd be less likely to buy the car back from you. In other words, they'd fight us in every single case, even the good ones, if they couldn't sell the cars they got back. So if they sell you a brand new car for $40,000 and you buy a $40,000 car and you're driving down the road and the transmission's bad, goes bad 4 times, and you get that manufacturer to buy your $40,000 car back from you get your $40,000 back. And now they've got the car, okay? They've got this car. If they had to take that car and crush it, they've got nothing. If they can take the car, recondition it, slap a new warranty on it, and disclose to the next buyer, hey, this car was bought back under our Lemon Law program, and we believe we fixed it, but we're going to extend your warranty for you, and you're buying it knowing that, and you're getting a discount as a result, you're paying less for it, they get to defray much of the cost of the settlement to them, which makes complete sense. So like I said, if they couldn't do that, they wouldn't buy the cars back as readily as they do. And likewise, if Volkswagen was told in this settlement, by the way, when you buy back 500,000 of these cars, they're all going to be stripped. Everything taken out of them. Window glass, deck lids, every single piece of sheet metal that can be removed. Hey, why not remove one tire? I bet you a skilled driver could drive that thing in under its own power with only 3 wheels. Why not? I saw A.J. Foyt do that once in the Indy 500, did almost a complete lap with 1 wheel missing. Okay? If A.J. Foyt can do it, why not you? So, if Volkswagen was told, you cannot count on selling these cars when you get them back, they'd be going, okay, instead of losing $15 billion minus what we can recoup from these cars later if we can fix them, we're just going to be out $15 billion. They'd be like, why would we settle this case? They wouldn't have settled it. So again, when you look back at the parties, at the moment they were considering signing this agreement, because this is a consent judgment, it's a stipulated order, which means that both sides, that is Volkswagen and the attorneys for the plaintiffs, both sides sat down and agreed. They came to an agreement and said, this is fair, this is fair. And at the moment they were all signing it, the plaintiff's side thought, we're going to be getting the right to sell these vehicles back under the Lemon Law and get these cars all bought back. Not the Lemon Law per se, but the same concept. And Volkswagen was thinking, hey, we get all these vehicles back, at least we can fix them, and if we can fix them, then we can sell them and recoup much of our money. If that element was removed from the equation, they probably wouldn't have signed, or they wouldn't have been as generous. They would have said, instead of $15 billion, tell you what, put up $10 billion. Because as you can imagine, these cars, if they wanted to, and they can't be fixed, they can be dismantled, those parts can be sold off, which is what these people who've got these cars now are trying to do for themselves. And if they were to scrap them and literally have them crushed, the stuff you remove from your car has weight, and much of that metal would diminish their value at trade-in for at a scrapyard. So again, for those of you who are looking at this and going, hey, maybe I can strip my car before turning it back in under the VW's TDI settlement, or again, because you're looking at the single definition of operable, which is a vehicle that can be driven under its own power. You've got to go and read the entire agreement and see the entire agreement is actually talking about Volkswagen getting these cars back intact and in a manner in which they can fix them and resell them later if they come up with a fix. So that's the sad news for those of you out there who thought you could do it, because sorry, you cannot return a stripped VW TDI, notwithstanding anything you might think you see in this document. Questions or comments, fire my way, as always, at my website, lehtoslaw.com, LEHTOSLAW.com. I'm on Twitter at Steve Lehto, at STEVELEHTO, and this show's on iTunes, Stitcher, SoundCloud, Podbean, Google Play, and YouTube. Thanks for watching and listening. Bye-bye.